Exactly 10 o'clock. We'll just wait a couple of minutes until a lot of the audience click in. We can see them all coming in quite quickly now. And we'll get underway at 1 minute past 10. In the meantime, we'll just fill another with a little bit of chat. So thank you everyone for registering. We've brought Andrew back from a webinar that we did last year. And we've had so many requests for more information. How's it all going? We thought, let's run another webinar and we'll just have a little chat session here, just 20 minutes long, but it might go a little bit longer. So we've got questions. We can take questions on the day. However, we may not get round to answering them. So please just send them in and we'll be able to get to them. So pretty well, let's get underway. So good morning, everyone, and thanks for registering. The new legislation came in on the 30th of January this year. Sorry. This year. I'll get it right, this year. Andrew, we wanted to check with him to see how the new rules and legislation had impacted on trustees and beneficiaries. So welcome, Andrew. Delighted that you could turn up again and be with us today. So before we start, I'd just like to give a big shout out to E3 Business Accountants. They help sponsor or financially support the Brainstorm Cafe to make all these webinars possible. And a special thank you to Oliver, our IT guru over here, is just sitting over there, making sure the sound is good, that these webinars get recorded and the lighting is good so you can see us. Now, the Brainstorm Cafe is a not-for-profit entity designed to help business owners overcome everyday challenges and problems. We've got a specialist team of successful entrepreneurs and business professionals, and obviously professionals like Andrew, to help join us and help solve some of the business problems that are out there today. But if you'd like to chat about anything that E3 Business Accountants can do, especially when it comes to family trust tax and doing annual accounts, please contact me after the webinar. So just moving on now. So a special thank you for Andrew joining us today. He's a partner with Mortlake McCormick, and Andrew helped write some of the, or draft the legislation, even though it passed through probably hundreds of committees and went on and on and on for several years. If you don't understand it, he's the man that helped draft it. But that means that he knows what he's talking about. So the webinar today will be coming from almost the horse's mouth. Sorry, I don't mean to refer to you as a horse, Andrew.
That's right, Jamie.
So welcome today.
Thank you.
And let's start by maybe just giving a brief overview of the major changes that came into effect on the 30th of January. What does it mean for trustees and what does it mean for beneficiaries?
So the major changes, as Jamie said, from 30 January are really about the understanding trustees' duties, understanding the trust deed itself, understanding what your administrative requirements are and your compliance requirements with the new Act. So those are the four headings, I'd say.
Right. So as a trustee, let's start with the settlers. Mm-hmm. Where do the settlers get involved? They obviously set up the trust and settle assets into the trust. So what responsibilities are there now on settlers, the original starters of a trust?
Well, probably nothing's changed in the life of the settler. Typically, mum and dad will set up the trust and mum and dad will put the assets into the trust. And they also probably will reserve to themselves special powers to hire and fire trustees and beneficiaries. So the Act hasn't really done anything to change that. As far as trustees go, that's probably where there's been a very significant change. The new mandatory and default duties are designed to really lift the standard of trustee performance. So you really do need to understand what it is, what those duties are if you are a trustee. For beneficiaries, beneficiaries have acquired a new set of rights in the legislation. Those rights are through what's called the disclosure regime, and we'll talk about that a bit more shortly.
So one of the things you've got in your notes here is that what people think they've got in a trust or their duties and responsibilities are sometimes quite different to what is real, because they may have set up a trust 20 years ago, mm-hmm. and now they can't remember what's in there, why they've got one. So tell us a wee bit about what a trustee right now should go and do.
probably read the trust deed. One of the things that's very common that I see in my work in helping people review trust deeds is a disconnect between what the deed actually says and what they think it says. So there's no shortcut or substitute for reading and understanding the trust deed, and we see a lot of mistakes being made, and those mistakes potentially could have quite serious consequences for you as a trustee if you haven't got it right.
What were some of the motivations to set up a trust in the first place?
Well, Jamie, you and I will probably remember in the old days, and when I say the old days, anything from 20 to 30 years ago, generally people set up trusts because obviously there were advantages for credit protection for business risk. There were certain tax advantages. There were certain advantages for relationship property planning, rest home subsidies, and succession planning when you had concerns around children. Either they were little and you didn't know what was going to happen to them in later life. So those are the main motivations for trusts. Over the last 10, 15 years, we've basically seen those whittled back to really two reasons. Asset protection for business risk still is a very common driver for trusts, and succession planning. That's as in the transfer of wealth from one generation to the next or the one after that. All other reasons really have largely disappeared. And again, we'll talk about relationship property shortly.
Okay. Asset protection. Let's say typically a lot of trustees have business activities, and they feel that if they take their assets and put them in a trust, they are one step removed from being exposed to the risk of being in business. Mm-hmm. Does that still apply? Is that still real?
That hasn't changed, and that's the advice that we would give people, and I still give to people. But I think it's important when we talk about risk that it's not in the abstract. It's something that you should be able to quantify or articulate exactly what my risk is, and is a trust the only way of mitigating or managing that risk. I think the old style of approach to trust, which was a sort of a silver bullet for every problem in life, that needs to be considered a bit more, because with a trust you have to balance, I guess, the obligations that are imposed upon you against the benefits you're trying to seek. So it's a balancing exercise, in relation to your own circumstances.
One of the big changes seem to be with the new legislation is disclosure. Mm-hmm. Now, I think that's worth spending some time on, because it's disclosure of what is the assets of the trust to the beneficiaries, informing the beneficiaries. What are the rules and guidelines around that now?
Well, that's a very interesting question, Jamie, and it's probably going to be the thing that's going to cause the most angst for trustees and beneficiaries going forward. So the legislation is very new, and it's going to take probably a good 10 to 15 years for some really decent court decisions to be made around disclosure. The way it's presented in the Act, it's a very literal interpretation of what you have to do. It's very, very basic. You must provide all beneficiaries, or trustees must provide every beneficiary with information about the fact that they are a beneficiary of the trust and that the trust exists for their benefit. The next level of disclosure relates to the response to that from beneficiaries. So, okay, I've been told I'm a beneficiary of the trust. So what's in it? What do I get out of it? Sort of what's in it for me type approach. The next level to consider are reasons why the trustees don't have to disclose. Might add that the disclosure regime is called a presumptive regime, which means it applies unless there's a reason for it not to in the hands of the trustees. So it's going to get tricky, because the Act makes it very clear the intent of the disclosure regime, why it was put into the legislation in the first place, was about providing some transparency, some openness, transparency, those sort of words that apply to a lot of legislation these days. And if you are wondering which way the courts are going to go on this, it's likely that the intent of the legislation is going to be the driver for how courts will interpret those presumptive regimes for disclosure.
So, should a trustee or trustees be proactive and produce annual accounts, balance sheets, and say to the beneficiaries, this is what happened in the last 12 months. This is the financial position of the trust as at the 31st of March this year, and I'm sending it all to the beneficiaries. Is there a need for a trustee or trustees to be proactive and do that and take the initiative?
Well, certainly the legislation sets out that trustees must be proactive, at least in providing that initial disclosure, telling someone that they're a beneficiary of the trust. We are going to be in a period of uncertainty, I guess, until some of those court decisions are made about exactly what trustees must disclose. My view and my recommendation is that you should be proactive, not just with the basic information, but going forward. If you think about what you've done with the trust, you have set up a trust for the benefit of all the people that you have named in the trust deed as beneficiaries. So they have an expectation. The law gives them a legitimate expectation to know about their position in that trust. So I think you are probably going to be better off as trustees if you are more open with beneficiaries. I think the old style, we talked about this before, about the hiding assets, the secrecy elements of trust as far as beneficiaries go, is probably not the way of the future. I put my money on that.
Right. What if one of the beneficiaries is a charitable organisation, whether it be Starship or whatever? Do the trustees have to go to that charity and say, you are a beneficiary, here's a set of accounts?
Yes, the legislation doesn't make any distinction in terms of disclosure between different types of beneficiaries. It simply refers to every beneficiary. And while we're talking about discretionary family trusts, where we have a list of people who might or might not receive something at the trustee's discretion, if you've named someone or someone is capable of identification, then that disclosure obligation is to those beneficiaries. So for people in trustees who might have had, say, any named number of charities, Cancer Society, St. John's and so forth are quite common, Salvation Army, you will have to tell those organisations that they are featuring in your trust deed if they are named. If you've just got a general reference to charities for the relief of poverty or for the assistance of medical research or something like that, then you don't have to go to all the charities in that space. As far as providing them with further information, that's really going to depend on what the response from the beneficiaries are. But I think in my experience with dealing, certainly in estate work, with a lot of beneficiaries who are charitable beneficiaries, they are keen to know what's in it for them. They're under enormous financial pressures. So if they think that they feature somewhere in your trust, then you can expect inquiry from them, certainly.
So if I suspect them I'm a beneficiary, but no one's ever told me, and I don't even know who the trustees are, there's no national register like there is for the Companies Office, where I can go to the Companies Office and I can see all the shareholders, I can see all the directors, where they live and so on, but I can't do that with the trust. There's no national register. Is there ever likely to be a national register for trust? Has that ever been discussed at your level?
Well, that was certainly something that the work I was involved in with the Law Commission and the Justice Ministry about whether there'd be a register. Essentially, it came down to a cost issue. So the answer is no, there is unlikely in the foreseeable future to be a register. So how do you find out? Probably if you suspect you are a beneficiary, a good place to start would be who you believe the solicitors or the accountants might be for the trust, and approach them and make that inquiry. And they will obviously act on the instructions of their client trustees, but if that were me, I would be recommending to my client trustees that they've got this positive duty. It's a much better look, as Jamie mentioned before, to be front-footing this rather than waiting for the letter requesting information, because it's not a good look from a trustee point of view. It also means that you have probably not understood what your duties are if you fail to meet that fairly basic obligation.
Now back to the settlers and the power of appointment of trustees, has that changed?
No. The ability to appoint and remove trustees is either found in the legislation if there's nothing in the trust deed about that. But if the trust deed sets out the formula or the roadmap for who gets to appoint and remove, that hasn't been changed at all.
Now, before you mentioned that, a lot of this will be made clearer when court cases arise, and you said 5, 10, or even 20 years to set precedents. So is the legislation not crystal clear? So you can read it and think that's what it's meant to say, but we won't know until a learned judge goes through a court case, and that could take years. Is that really the situation here?
That pretty much is. The legislation that we've got, remember, was playing catch up with probably about 60 years worth of where the law had been interpreted through the courts. And so the clock has sort of been reset, if you like, for how contemporary standards sort of exist. But it's important to remember that the legislation did not prevent the further development of common law, and that's judge-made law, court law. So as cases are litigated, and remember we have a tier of courts that appeal courts that go up to the Supreme Court. So until there are some fairly substantial and landmark Court of Appeal and Supreme Court cases, there will be no certainty for trust. But I think the winds of change and if you like, the sort of the leaning in favour of beneficiaries against trustees is clearly the direction of travel under this new legislation.
Right. Now, one of the other interesting things you've mentioned here is relationship property. Now, I recall many trusts were set up, as you mentioned earlier, to protect the assets or the family assets from being exposed to relationship issues, especially with their children. You might have a daughter who's got a partner that you think's a bit ropey, or the other way around, and you think we've got a trust and that'll help protect the assets of our bloodline. So what is changing in that area? You've mentioned here relationship property between trusts and so on. You want to spend a couple of minutes just covering that, and we can do it in 2 minutes.
I could spend a couple of hours on this topic, Jamie. So there's a great deal of tension between trust law and relationship property law. We have in New Zealand, and have had since the early 70s, a relationship property regime and matrimonial laws, if you like, that provide for a very simple division of relationship property in the event that the marriage or the relationship ends. Now, that's fine when everything was owned personally, but because of the rise of numbers of trusts, a lot of assets are now, that would have been relationship property, are actually sitting in a family trust. And so it is, on the face of it, outside the reach of the relationship property regime. So the courts, lawyers, and other people have been very active at sort of trust busting to try and pull assets out of trusts and put them back into the relationship property space so they can be divided. And by and large, that's been successful. And the relationship property regime has developed a number of mechanisms that allow courts to look at a trust and say that would have been relationship property but for the trust, and pull that back out. And trusts now are very, in certain circumstances, very hard to defend against relationship property claims. Where we've got to in terms of case law is essentially, just because it's in a trust doesn't mean it's not beyond the reach of relationship property claims. So that is certainly a reason that people perhaps in first and second relationships, second relationships, might have put assets into a trust, or, as Jamie's mentioned, you've got concerns around your children, and it's a natural concern that parents have, that they want to make sure that what they've worked hard for is not lost in subsequent relationship property claims. I think what that does underscore is the need for approaching relationship property issues in the relationship property space and not thinking about them in the trust space. And the easiest way that people can coexist between relationship property rights and trust rights is the use of Section 21 agreements, more commonly known as prenups, but they are the thing that enables you to regulate what's relationship property and what's trust property and keep them separate.
Right, now I see some questions coming through here. This is being recorded and it will be distributed via email later on today. We'll send a link out with that email so you can click on the link and go to a replay so you can see all this again. So if you have to run away right now and you can't last the distance, that's fine. You can come back to it. Now, I'll just see if there's any questions in here that I can pass on to Andrew. Oliver, will you just scroll down so I can pick up a question on the screen here? There's quite a few that have come in.
I think there was a question about trustee replacement that came up earlier.
Right, yes.
And so the question was, if a trustee retires or dies, I guess, how long do you have before you have to replace them? And that's quite important. So the trust deed will dictate, for a start, the minimum number of trustees you must have. So just because someone dies, you don't necessarily need to replace a trustee, because it might say the minimum's 2 and you might have had 3 or 4. So again, going back to your trust deed and finding out what needs to happen. But essentially you need to move as quick as you can to replace a trustee, because if the trust is not operating with the minimum number it needs to, then the trust can't operate. So that's probably the key message. There's no magic time limit, but you might find the trust is stuck until you get a new replacement in there.
Many trusts or trustees are mum and dad.
Mm-hmm.
And being a trustee has deep responsibilities. What is the recommendation to have a professional trustee? That adds cost, but it also adds, I guess, a degree of it's no longer a sham trust. This is a real trust with a professional trustee. What is your thoughts on mum and dad trustee versus a professional trustee?
Well, I've always taken the view that the presence or absence of an independent professional trustee is not the hallmark of whether the trust is a sham or legit or not. It's the functioning of the trustee. So if mum and dad can manage what the law requires them to do, then I think that's good enough. And I think what that means for mum and dad, who aren't lawyers or accountants as trustees themselves, is to get advice. The law doesn't require trustees to be experts in all things trust law, commercial law, financial, and so forth. But what the law would require trustees to do is to recognise the limits of what their experience is, and to get advice when they think they need to. So that's probably the best defence. I think it's very hard, and I say this from personal experience, when I have previously been, and I'm certainly not now, an independent trustee with mum and dad. If you think about it, often mum and dad are having conversations that are effectively trustee meetings over the Weet-Bix in the morning, and I'm generally not sitting at the kitchen table at the same time, and it's hard to engage in conversation when mum and dad have already made up their mind and they just want you to do something. So I think it's about trustee performance. It's not about the look of it.
Now, another question that came up, which I thought was quite good, a pro forma report. Is there a standardised pro forma template or report that trustees should provide to their beneficiaries every year? What does it look like? What's the contents of it?
There isn't such a thing. It will depend on what your trust has. For many family trusts that simply own, say, a family house or a batch, there might be non-income earning assets, so there might not be any financial statements being completed. It's going to depend. I think if you have just very simple assets in a trust, even if it's just the family home, as a minimum, the trustee should be having, say, an AGM every year. They should be having regard to the fact that, is the property maintained? Is it fully insured? Are the rates up to date? Who's living in the property? Probably mum and dad. So the beneficiary mum and dad are living in the house. What are their obligations in terms of maintenance? What's a repair item? What's a capital improvement item? Who's going to pay for it? So just those sorts of things need to be recorded. Write them down. Trustee minute to that effect, and a resolution approving a course of action. If you've got assets that are a bit more complicated, you might have shares from a business, you might have investment portfolios, that sort of thing, then generally you'll have accounts done, and it's probably linking the preparation or the completion and approval of the financial statements to making sure that everything else that's happened in the year has been captured. So there's not a template or right and wrong. It really does depend on what you're dealing with, what the trust has.
The word discretionary appears in many trusts, discretionary trust. And has that changed? What does that actually mean, the word discretionary, in this context?
So the law hasn't changed what it means to be a discretionary trust. But what a discretionary trust is simply you have a range of beneficiaries who qualify when the trustees exercise their discretion to help those beneficiaries. That's the magic of discretion or discretionary trust. It's when the trustees decide. So you can have mum, dad, kids, grandkids, uncles, aunties, whoever you want to have in your trust deed, but they only benefit when the trustees allow them or exercise a discretion in their favour to either provide housing, provide money, provide some sort of financial assistance, that sort of thing.
We've got many questions coming in. Just a couple more I'll read. We've now 25 minutes into our 20-minute webinar. So even though you didn't pay a lot for it to be here today, you're getting good value. Now, Nola says, we don't have any assets in our trust now. Can I leave it as it is, or do I need to wind it up? And how would this happen? Or will set up the trust so these wills will still be current? So there's quite a bit there.
Look, if you've got, and a lot of people in that position, Nola, they've got the assets may have come out of the trust. I think you want to be conscious. Either you want the trust or you don't. If the trust isn't providing any value to you, then I think you should really wind it up. And the wind up mechanism will be in the trust deed itself. Generally, that's not a big drama, particularly if you don't have any assets to distribute in the trust. But I think, again, trusts shouldn't just be left in the background if you don't want them. Make a conscious decision to wind up the trust and update your wills to make sure that everything that has come out of the trust sits with your wills.
Now, the lifetime of a trust used to be, was it 80 years? Now it's gone out to
125.
125. Well, that should see you and me out.
I think it will.
So what was the purpose of going from 80 to 125 years?
So what the Law Commission looked at was the expanding life expectancy of average New Zealanders. Back in the 1950s, 80 years probably would have seen 3 generations of a family out. So really that's the motivation before it. It's to make the trust last a lot longer. It's a really interesting issue. Should you take advantage of extending the trust to 125 years, that's really forecasting that you're anticipating the trust is going to be around for a long time. It makes it very hard to know what future generations of your family are going to look like, what might be in the trust. But look, for some intergenerational assets such as farms or business assets, that might be a very helpful provision to be able to basically kick the can down the road for several generations.
Right, one more question, but I will say, Natalie said, excellent info, thanks so very much. So we've got somebody to say thank you already. We appreciate that. But one last question from Karen. Is it possible to remove beneficiaries?
Again, it depends on your trust deed. So the law won't help, the new act won't help you, but the trust deed does. And typically most trust deeds, most modern forms of trust deeds, that is the last 20 years worth of trust deeds, will allow beneficiaries to be removed. And so what I'm recommending to people is that when you look at your trust deed, and if you've got a very wide class of beneficiaries, as I say, mum, dad, kids, grandkids, but if it extends to siblings, parents, blood relatives, whole of other people that you realistically are never going to benefit, you probably should be looking, if you can, to trim that down to actually who you mean, to refocus the trust to those that are likely to receive the benefit of that discretion, because it reduces your, I guess from a trustee point of view, your audience, it reduces your risk, and it keeps family business sort of a bit in the family. If you've got to disclose to nieces and nephews, it might not be something that sits comfortably with mum and dad, and that's what we typically find. I think when a trust was set up, often if kids were little, if they were say 2 or 3, and you didn't know whether they were going to last, or you were all going to be killed in some horrible accident together, you tended to put in siblings and parents and nieces and nephews. So it's thinking about how that fits with your family now.
So one last question. We've had several last questions on tax.
Yes.
Flat tax rate for companies is 28%.
Mm-hmm.
Trusts are 33%,
mm-hmm.
right across the board.
Mm-hmm.
And now the personal highest tax rate has gone to 39 cents. Mm-hmm. Have you noticed anyone coming to your firm to say, we want to be able to take benefit of the lower tax rate in a trust know that the highest tax rate is at $180,000 at 39 cents. Probably you fall into that bracket. So have you seen a move to take advantage of the lower tax rate in the trust?
There's been some inquiry in that regard, but what I would say, and it's being signalled by the IRD at the moment, is that the IRD were very opposed when the personal tax rate was increased to 39, that the tax rate didn't go with it. There are a number of reasons why the IRD weren't happy with that, and it's a lot to do with maintaining the integrity rules around our tax system, not to create a two-tiered system. The government were in a position where they'd promised absolutely no new taxes, and so I think there was a political motivation not to increase the tax rate. My pick is that come election 2023, you'll find Mr. Robertson saying, should all these people out there be getting advantages over the hardworking taxpayer paying 39 cents, and you'll probably find in the Labour manifesto for 2023, it'll be upping tax rates. That's my pick.
Right. Well, thank you. We did have Mr. Robertson as a guest here a few months back before we knew what the tax rates were going to change. So that would have been a good question to ask him. I might get him back.
The cynic in me would say that's the direction of travel.
Right. Well, look, we're going to finish now. Thank you for everyone for registering for the webinar today. A special thank you to Andrew for coming along and giving up his time to help answer some of these questions. All the ones that have come in that we haven't been able to answer on air today, we will go through them over the next couple of days and come back to you. So thank you again. And remember, if you need some accounting and tax advice around your trust, come and see me after the event here. Send me an email. So thank you very much, and we'll let you know shortly about our next webinar. Thank you.